Live stream যদি ওদের ব্যাপার আমরা we are unmuted now, not mute.
This matters for hearing, my lords, and there is private respondents are also there, my lords. I think he's the other side, Mr. Kumar.
But Mr. Kumar,
He does not. He's not here, madam.
He has informed he will not be available to this matter.
So hearing
Ladyship and my lord,
for quite some.
Doesn't all the more reason why we should take it up. All the more.
ladyship is
Yes.
ladyship and my lord.
1 minute.
Paper book.
Paper book. There was a direction for paper book.
Yes.
Paper book contains all the documents.
Yes.
Yes, so Mr. Kumar had paid for an adjournment on the last occasion also, 17 January. Yes, what about this direction on 20th November? So all the papers are now here with the
Ladyship and my lord, we have submitted the papers and we are willing to argue on the basis of whatever we have submitted.
No, was there any supplementary affidavit pursuant to this direction? Any supplementary affidavit filed for you?
Pardon? Ladyship,
Liberty given to you on the affidavit. You done it?
my apologies, I am not able to hear properly, but here the petitioner is agreed with judgment of Central Administrative Tribunal upholding the selection process for the government post in question.
Mr. Shivgupta, please speak into the microphone. We can't hear you properly.
Yes, there is some problem. Echo is there.
Sorry?
Echo is there.
If there is echo, then how will they do the matter? If there is echo, then how will they do the matter? We have kept it because you have asked us to keep it.
But may I try?
Yes, yes. Where is
Am I
the
audible now?
where is the order?
Yes.
Order is
Order is that page 16 to 30 of the
Where is
paper.
the order? Where is the impugned order?
Yes, my lord, it is at page 16 to page 30 of the paper book.
What is the can one?
Tribunal upheld the selection process to the government post in question
Please give the court.
on the ground that on the basis of selection made on the basis of written examination.
What is can one for?
Yes, ladyship. Let me try to explain in a few minutes. The tribunal held that
We can't. Please log out and log in again, please. Yes.
Okay. We'll log out and log in again. All right.
yes,
Most of us.
most of them.
The first paper book was filed. After that, Mr. Kumar pointed out that some papers were missing. Then, my lord, there was a direction for supplementary paper book, and another friend is pointing out that the petitioner will file the supplementary paper.
Is it part of record, Executive? Supplementary affidavit, paper book. It is supplementary.
Ladyship and my lord, are we audible?
Are we audible now, your lordship? কিচ্ছু শোনা যাচ্ছে না যে।
Are we audible, ladyship? Unmute.
কিচ্ছু শুনতে পাচ্ছি না। At all. Nothing. কি করি? একটু আগে সকালে টেস্ট করছিলাম তখন তো শোনা যাচ্ছিল।
We are extremely sorry. We are unable to hear right now. We are trying to.
There's no sound from that side, your lordships.
Ladyship, there is no sound from that side. We are unable to hear. PBD2. It is PBD2 SMH.
Your lordships. একেবারে কোনো সাউন্ড নেই।
They are not hearing us. আমাদেরকে মিউট তো করে দেয়নি।
না তাকে মানে ওনারা দেখছেন এদিকে, probably they are also trying.
সব্যসাচী আমি কালকে চিঠিটা পাঠিয়েছিলাম যে তার শোষণের রেজলিউশন হতে হবে। আমি বললাম যে এটা কবে কবে হবে, তখন বললো যে যদি কালকে হয়তো ন্যাচারালি কালকেই হবে এই উত্তরটি। সৌভিতরকেও তো কিছু বলিস না, ছিল বেশি কি লয়ার ছিল? আচ্ছা, আমি তো মনে না আমি লয়ার ছিল মানে আমি তাকে দেখেছি বলে তোমার মনে হচ্ছে। তো আমি ব্যাটারি করি স্টেটের ব্যাপারে এখন দেখছি আর্বিট্রেশনে চারটে করেছি না, কিন্তু স্টেটের আমার ঘরে স্টেটের যেগুলো অ্যাসাইনমেন্টের চেঞ্জ এখন তারা ঘুরেছে। আমি অনেক মেয়েদের দেখছি এখন স্টেটেড হয়ে করে, নোয়েল ব্যানার্জি গুলো সে করে দিচ্ছে। আগের দুবারে কিন্তু আমি শুনতে পাচ্ছিলাম না, একটা প্রবলেম থাকে এখানে আমরা আসলে যাতায়াতটা এক্সপেন্সিভ হয়ে গেছে না, আমি শুনছি অত তো কাটিয়ে দিতাম যদি এটা জলপাইগুড়ি হতো একদম কাটিয়ে দিতাম যে 3 বার 4 বার হয়েছে শোনা যাচ্ছে, কিন্তু আন্দামানে তো ওটাই প্রবলেম। আমরা এক্সপেক্ট করতে পারবো না যে প্লেনে করে আসবে, আর প্লেন ছাড়া তো কোনো উপায় নেই। এই জলপাইগুড়ি তো ট্রেন, এতগুলো ট্রেন আছে আছে। আমি তো এখানে টিকিট ডক্টর, তারপরে আরো অনেকে এখানে ম্যারাথন বানিয়েছে, ছিল মানে তো এখানে অনেক মানুষ ছিল। আর একবার যদি একটা কেউ কাজ করতে আরম্ভ করে তারা ধরে নেয়, তখন তো অটোমেটিকলি সব কাজগুলো দরকার চলে যাবে। আমার ঘরে যখন এখন লাস্ট 1 বছর মনে হচ্ছে আগে মানে ওনাকে না থামানো যায় না। খুব যদি তুমি হাঁটিও করে, মানে ওনাকে কিছুতেই তুমি মানে থামাতে পারবে না। আর আমি যেটা চেষ্টা করি ইয়ে করতে, স্টপ করতে, সব কনসেপ্ট সেখানে মানে উনি বলেই যাচ্ছে বলেই যাচ্ছে যে হম হম হ্যাঁ 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 সেসব তো আছে একদম। একজন যেরকম আছে, মানে অনেকেই আছে যারা তুমি দেখে ভালো আর্নিং করে, কখনো চোখ বুঝে তাকে বেশি থাকতে পারে। যেই তুমি দেখবে একটা ডকুমেন্ট খুলবে দেখবে অন্য একটা কিছু আছে, বাট হয়তো অন্য একটা কিছু নেই, বা হয়তো সেই ডকুমেন্টটা এমন একটা কনস্ট্রাকশন দিয়ে দিল যে হ্যাঁ ওরা এই কথাটা বলেছে ডকুমেন্টে, তুমি দেখলে যে ডকুমেন্টে সেরকম করে বলা নেই, একটা অন্য একটা কিছু বলা আছে। মুশকিল। মনোজ, কি হলো জিজ্ঞেস করতো? জয়েন করছে না?
There was a problem, yeah, my lord. This problem is now resolved. Now they have to send the request. If they send the request, she can't admit to.
থ্যাংক ইউ মিস্টার। জিজ্ঞেস করতে এদের নাম্বার আছে কি?
बोल के जाइए
এই যে অ্যাডভোকেট অনেক করে নাম্বার আছে কি? তাহলে ইউ কল হিম না, কল হার।
I may be allowed to.
Yes, go, please go outside. Call her বললে এইভাবে হাতটা উঠে, কল পেবি, কল হার, কল হার। আপনার কাম করছে বলে আছে না, এদিকে মেনশন করছি। Mr. Chakraborty, where is the impugned order?
Page 16 one. Paper
What? Paperbook page 60.
365 pages.
ওরা ওবিসি ক্যাটাগরিতে অ্যাপয়েন্টেড হতে চাইছে না, ও প্রাইভেট রেসপন্ডেন্ট। একটি টেকনোলজি ডকুমেন্টে দেখে আলটিমেটলি
That's the problem with it. That is why. It's a matter of
Mr. Chakraborty, what is this Supreme Court order and the circuit bench order?
I know,
At page 18, page
yes,
D.
my lords. Initially, my lords, yes, my lords. Initially, my lords, their contention was that there cannot be viva voce because the recruitment rules do not provide for viva voce, and on the basis of written examination, the decision should be taken. So, my lords, this traveled up to the Supreme Court, and then, my lords, Supreme Court said that from the stage of written examination you have to conduct, you cannot conduct viva voce. Now, my lords, the administration then only on the basis of the written examination appointed the private respondents, because that is what the rules provide for. Now they are now trying to say that some further steps were required to be done, but the CAT has held that it was your own contention that it should not, viva voce should not be taken into consideration. If the recruitment rules only provide for written examination, then assessment has to be done on that basis. So there is nothing wrong with what the administration has done.
So their only grievance was that there should not be any viva voce.
That was their grievance in the first round, my lord. But my lord will see the page 22, 23.
No, because Square B talks about the Supreme Court order in terms of the Supreme Court order and written examination in the light of the decision made by the Honorable High Court.
Yes, ma'am.
5th April and Honorable Supreme Court on 2nd April.
Those my lords are also set out in the impugned order. I'll just, my lords, invite your lordships to that. Kindly have page 26 first, or 25 bottom of the page, para 9.
Yes.
It says that aforesaid rules only prescribe written examination. There is no provision or condition for conducting viva voce test in addition to written examination. As noted here and above, initially respondents in contravention of aforesaid rule published merit list of the candidates who participated in selection process held for filling up pursuant to notice. Respondents had conducted written examination as well as viva voce by considering total marks obtained by the candidates in said test, had published the merit list as well as offered. In this regard, we refer to appointment order. Since the said selection process and appointment order was in contravention of the provision of recruitment rule, came to be challenged by private respondents before tribunal. Tribunal on 21st August 2012 quashed and set aside the selection process as well as appointment of the applicant herein, mainly on the ground the respondents have not adhered to the provision or rules, and it had further directed respondents to re-advertise the post. Aggrieved, the applicant along with others had approached the Honorable High Court by filing WPCT by way of common judgment dated 5th April 2013, passed by the Honorable High Court, partly allowed the writ petitions with the following directions. So far as written test is concerned, we find that it is not at all a case of either of the parties that there was an illegality in the matter of holding the written test. So the order of tribunal for re-advertisement for the entire selection process cannot be sustained. The appointing authority should be directed to proceed with the selection process from the stage of written test. They shall be directed to adhere to the rules that were advertised for the recruitment. The question is thus answered. Accordingly, we are of the view that this application should be allowed. An order of the tribunal should be modified. The application is therefore allowed accordingly. Impugned order whereby the tribunal are directed to re-advertise the post is set aside. Appointing authorities are directed to proceed with the process of selection from the stage after completion of written test, and they shall adhere to the rules framed for recruitment. Aggrieved by the said judgment, the applicant along with others approached the Honorable Apex Court by way of civil appeal. The said appeal filed by the applicant along with others came to be dismissed with a judgment dated 2nd April 2014, wherein the Honorable Apex Court, while upholding the directions issued by the Honorable High Court, observed that
Mr. Chakraborty, sorry to interrupt. Why is it going on saying there is only one applicant before the
it says applicant along with others. There are other applicants. My lord will see paragraph 20 of the Supreme Court's order which has been set out. In the instant case, the rules of the game had been changed after conducting written test and admittedly not at the stage of initiation of selection process. Marks allocated for the oral interview has had been the same as for written test. The manner in which marks have been awarded in the interview to the indicates lack of transparency. The candidate who secured 47 out of 50 has been given only 20 marks in interview, while a large number of candidates got equal marks. Candidate who secured 34 in written examination was given 45 marks. Similarly, another candidate who also secured 36 marks was awarded 45 marks. In the fact that today the so-called selected candidates are not in employment is relevant factor. If the whole selection is scrapped, most of the candidates will be ineligible, at least in respect of age. Thus, in the facts of this case, the direction of the High Court to continue with the selection process from the point that it stood vitiated does not require interference. In the above, in view of the above, the appeals are dismissed. Kindly see after that what happens. Further, it is noticed that in compliance with the aforesaid direction of Honorable Apex Court, as well as by adhering to recruitment rules, respondents issued impugned order, whereby the candidate who has received highest marks in written tests conducted by the respondent with respect to employment notice have been appointed to the post of chairman. In view of the above factual matrix, we are of the considered opinion that there is substantial force in the submission of the official respondents as well as private respondents, that the respondents have considered the marks obtained in written examination has been considered only in terms of the recruitment rules as well as directions issued by the Honorable High Court and Apex Court. And my lords, on this basis, my lords, the CAT has rejected the original application.
Yes, they've also underlined this excluding the mark of viability test.
Yes, ma'am. Respondents are
Yes, yes. Mr. Chakraborty, sorry. Yes, can you hear us now?
Yes, yes, yes.
Yes, Ladyship.
Yes.
We are
we
able
can't
to
hear
hear
you.
now.
I
Ladyship,
don't think we can get out of this one-way communication.
we are able to hear you, Ladyship.
Mr. Shengupta, yes, we can't hear you. Sorry. The court waited for almost half an hour for hearing learned counsel appearing for the petitioners on the virtual mode. Stop. However, comma, either the court is audible or the or counsel, comma, but not however, comma, either the court is audible at some point of time or counsel, comma, stop. It is impossible to conduct this matter on the virtual platform due to some technical issue or another. Stop. Next. We have heard learned counsel appearing for the respondent. No, take care of it. Learned counsel appearing for the respondents has taken the court through the impugned order dated 21/2/2023. Impugned order passed by the tribunal, capital T, dated 21/2/2023. Stop. First line should be that this matter was listed on the last day of the circuit and repeated mentioning by learned counsel appearing for the petitioners. Stop. Then what? Then the next paragraph. Next, paper books are already a paper book. Paper book. A comprehensive paper book is already on record, and together with a supplementary affidavit filed by you, Mr. Chakraborty, together with a supplementary affidavit filed by the petitioners. Stop. Next.
Ladyship.
Learned counsel appearing for the private respondents. Adjournment was prayed for on behalf of counsel appearing for the private respondents. Stop. We note that similar prayer had been made Also on the last occasion. Stop. Yes, what are you showing us? We can't hear see. What? Written submissions. Yes. Next, yes, না যেটা করতে পারি লিবার্টি দিতে পারি কি ফাইল সাবমিশনস ইন 2020 বেঞ্চ এন্ড কুইকনেট মানে এটা তো মানে খুবই খারাপ অবস্থা মানে কাউন্ট দেখে দেখে আগেবারে অ্যাক্টিভনেট করছে নেক্সট লিস্ট দিস ম্যাটার Now, despite our best efforts, this matter could not be taken up. This matter could not be taken up despite our best efforts. Stop. Next, list this matter before the next circuit bench. Stop. Council are learned council are given liberty to file the written notes of submissions, as prayed for on behalf of the petitioners. Stop.
Highly obliged.
Written submissions, before the next circuit bench, before the matter is taken up by the next circuit bench. Now, written submissions before the matter is taken up by the next circuit bench.
Obliged.
মানে এটা আমরা শুনে যে ওদের রিলিফ এটা না মানে বাইরে বলছি যদি ওদের
এখন তো শোনা যাচ্ছে।
বাদ দিয়ে রিটেন টেস্ট হ্যাঁ হ্যাঁ তো আমাদের তো বেরোনোর জায়গাটা তো নেই মানে ওদের কি রিলিফ দেবো আমরা
Item number 2. Here it will be on a further degree.
নোটস গুলো দাও আচ্ছা ইয়েকে নিয়ে আসতে বলো Yes, Mr. Kabir.
Madam.
Where where will we get the narration of the facts?
Facts I have not given you, Lordship.
No. We are not asking you to give it. Just and you have given the headings. Yes, 15 headings, or is it more? Yes, 16
16.
defects in the so that is the main.
The defects are where I am saying that the judgment is perverse and requires to be interpreted with. This is my gateway. If I surmount this gateway, then your Lordship see the other circumstances and the chain of circumstances.
তুমি And what are the, where have we discussed the sections? Note point 16. Point
The-
16.
The sections with regard to money?
No, defects in the interim judgment, you have
But-
mentioned the section.
Defects are at, no, those I have mentioned specifically with regard to the paragraphs where the court has entered into a discussion or has not considered. To demonstrate that the judgment is,
Very well. So where have we mentioned the relevant sections? Remember, we asked you on one of the occasions that what is the, you said, if I'm not mistaken, 386.
the powers of the appellate
Yes,
courts.
yes, 386.
Madam,
So apart from 386, what are the others we need to look at?
no, madam, 386 is all. And if at all, if your lordships are of the opinion that this court is going to start taking additional evidence, then maybe 391.
And the fact that on an acquittal, if we find that, remember we asked you the possibilities,
My lord,
and you said one is if we find that the judgment is perverse,
my lord,
then we can either send it back
my lord,
for a reconsideration. That is under which section?
my lord, there are 4 things that can be done here.
Yes.
First of all is in terms of 386, if your lordship finds that there is no merit in the appeal, it goes straight away and the appeal is dismissed.
Yes.
Assuming that there is merit in the appeal and the judgment is perverse, your lordship then has 3 options. The first option is to remand it back for consideration of all the materials that have not been considered and for a reasoned order to be passed thereon. Second, if your lordships are of the opinion that the charge itself was also defective because this was a case of murder under 302, but the charge inexplicably has been read down only to 304 on the draft charge given by the prosecution. If your lordships feel that no, this is a case of 302, then technically there needs to be a de novo trial.
Yes.
Because it has to go back for framing of a fresh charge under 302, the accused need to be put on notice that there is a charge of murder against them and not only culpable homicide. Thereafter, the evidence such as it is can remain. Any additional evidence that needs to be taken on the issue of murder can be taken separately by the trial court. The third alternative is that this court here and now says, I'm not sending it back. There is an illegality in the judgment. We are considering the materials, reappreciating the evidence because the Supreme Court judgments which talk about the reversal of acquittal allow the appellate court to reappreciate the evidence afresh. So the court says, we are not sending it back to the court below. We are appreciating the evidence and this is our finding.
So what is the additional circumstance between 2 and 3? Instead of us saying that we are sending it back for a trial de novo,
My lord.
why, what is the additional circumstance for us to say that no, we will not send it back, but we will
The
consider?
lordship say that there are illegalities, but the evidence that is on record is already making out a case.
Yes.
The court has failed to apply its mind, has given a perverse order. Therefore, we are interfering with that and on the basis of the materials that we are considering, we find the chain of circumstances complete. Hence, we are reversing the acquittal to a conviction. And we are imposing whatever necessary sentence needs to be imposed. That your lordships can do. The problem with that is if your lordships are of the opinion that this is a case of murder and not 304, then technically a prejudice is being caused to the accused because he never faced a trial of murder. So in that event, your lordship will have to send it back. But if your lordship says, okay, after time has passed, now nothing is to be achieved by a de novo trial, therefore we are going with 304 and 304 appropriate sentence may be given because 304 goes up to life. This is 304.
So if we find that it to be a case of 302
My lord,
and not 304,
my lord,
we can either send it back for a de novo trial or we can say that we will consider the evidence.
technically no, your lordships cannot because there was no charge under 302, there is a prejudice to the accused. There will be arguments on both sides there. The Supreme Court's position is even if a specific charge was not framed during the course of the proceedings, if they were made aware that the charge that was actually one of murder through the 313 examination, through the materials of the prosecution, then they would be held to have had adequate notice of the charge being one of murder. That is my point that I would argue. Because the entire record is 302, the charge sheet is 302, cognizance was 302, everything was 302. But we can obviously argue in a higher forum that we were prejudiced because the High Court
As
has,
of now, the charge sheet is under 304.
the charge sheet is 302.
Two. No,
What
but-
happened is that the charge sheet is submitted by the police on murder.
yes.
The prosecution, for an inexplicable reason, is asked to submit a draft charge. That always happens that you give a draft charge.
Yes.
But the prosecution, instead of giving 302, goes and gives 304. Now the judge says nothing, the prosecution reads down a section from murder to culpable homicide. The judge says nothing and frames the charge under 304. That is where I said an inherent illegality happened in the beginning of the trial. You could not convert a case of murder to one under culpable homicide without recording reasons for it.
Yes, but our question to you is, Mr. Kavi, that if the charge sheet was under, if the charge was under 302,
My lord.
then what is the technical difficulty for us to?
Because the charge was not 302, the charge sheet was 302.
Very
The charge is 304.
Very well. So the sections are only 386, 391 and.
Along with this, madam, may I say popular Muthaiya says that 482, the power to do inherent power to do justice, and act ex debicio justitiae inheres in an appellate court as well. So popular Muthaiya directly vests your lordship's authority to whether this is an appeal court.
Yes, but I don't think you have relied on any decisions. Have you?
No, no,
You have given a list on the last page.
Yeah,
but,
but popular Muthaiya is not really required to be relied on.
It's not here.
Alright, I can add it in. I can add it in.
No, no, but have you relied on these decisions on the at page 8?
Alright, all of these decisions I'm relying on at page 8, which I explained that day in brief. The first three are with regard to reversal of acquittal. If your lordship recalls, I said one of them is slightly against me, the other two are for me. These are all principles which talk about where an appellate court would interfere into a finding of acquittal because there is a second presumption which is reinforced. The burden of innocence, the presumption of innocence has been reinforced, and that the court would interfere only if there is a perversity shown on the face of the record that the learned court has passed an illegal order. Those are the first three. So far as Satish is concerned, I had demonstrated to your lordships that the case with regard to a delay in examination of witnesses by the prosecution, if the delay is adequately explained, then this does not form a problem with the prosecution case. Mir Muhammad Onar with regard to 106, where I had said that once the prosecution has made out a prima facie case, the burden shifts on the accused to explain.
Yes.
Bhaskar Tushar Kotakar was with regard to non-examination of the IO, because we had both said that the non-examination of the IO will not be fatal to the prosecution case unless it is shown that a prejudice was caused to the defense by the absence thereof.
What case was that would not be fatal?
My lord, my case was that even if I discard PW9, first of all, I test PW9.
Yes.
If I cannot cross-examine PW9 to the extent that PW9 has made certain statements which they say he never made to the police, I am unable to examine the IO, therefore I cannot test whether he made these statements to the police or not. Even assuming I discard PW9 by that logic, which is the court's logic, the rest of the circumstances still remain. PW9 changes the case from one of circumstantial evidence into eyewitness case. Even if I discard PW9, the circumstances remain, which the court has not discussed. Rather, the court at one paragraph has said all 5 eyewitnesses are going. That was a complete misunderstanding of the case. There were no 5 eyewitnesses.
Yes.
Number 7, Selvi was with regard to detection of deception, polygraph, narco, and P300 brain mapping, where it is admissible, how it is admissible, consent, those aspects. And I had also pointed out there that Selvi is quite clear that this is not substantive evidence. It will not be admissible by itself, but it is used to corroborate or to strengthen other circumstances that exist. My learned friends had argued here that Selvi means that there must be a recovery under section 27. On the basis of your statement, if something is found, only then Selvi will allow these to be made operative. Those are the two sides.
It doesn't help you, does it?
No, Selvi helps me to the extent that they make consent.
Yes.
These tests are carried out. These tests are recognized in Indian criminal jurisprudence. So even though the result of the test is not something which is admissible, the opinion of the expert that this person knew something about that incident and had prevaricated on that is something which is admissible. So these people, for example, under the narco analysis test have said, I hit him, I beat him to death, I did that. That statement is not admissible. But the opinion of the expert that the person
that I beat him to death.
Yes, yes, yes. That is the reports I have.
How can the narco analysis test say make the victim
Because
make the accused say that I hit him and
because the narco analysis test, your lordship will recall, for example, the movie Guns of Navarone, sodium pentothal. In those days, it was used as a truth serum. Sodium pentothal now is used in order to induce a trance. A subject is taken through 4 levels of consciousness into a trance state, where he is asked to narrate whatever he wants to about the incident. And in that trance state, these two accused narrated the entire incident.
That
That they were the murderers. That they described the entire thing. And that forms part of the report. But I'm not saying this is substantive evidence. I'm not saying the court will rely on their confession under a trance state, because this goes against the basic principles of testimonial compulsion. Even if you are giving your consent, you're making your body speak against itself, which is something which violates Article
Article 20.
20+3.
Yes.
So that is why I'm not saying this should be admissible. But what is admissible is the expert's opinion. The expert opinion there, along with that report, is they are doing what is called BEAP. The brain electrical activity is being mapped. That is P300. The brain produces a certain frequency of waves at this P300 frequency, which can indicate the brain is responding to some stimuli. So say, for example, they are examining this person in brain mapping, they will have, say, 50 words. So out of those 50 words, 20 words will be innocuous words, which have nothing to do with this case. One or two of those words will have something to do with the case. And some of those words will have something directly to do with more involvement in the case. So it's a very simple thing to understand that the brain line will show a line when there is a word which does not activate the brain, that means it's a negative. When something activates the brain, it's a positive. So that brain mapping test also, together with the narco test under the trance situation, these people were defined by the expert to have knowledge about the actual death of the deceased. That was the expert opinion. That is admissible in terms of Section 35 of the Evidence Act.
The report.
The report. The content of what they said.
Not the nature of the test, but on the report. You're relying on the report.
May I just show you much of the report for a moment, because that will make things a little clearer.
Mr. Tabriz, what do you have to say about the report?
My friend has
I've
taken the paper.
stolen his paper. If your lordship just says page 140, I'll explain it first.
Test was conducted in a.
Selvi.
Selvi. It came later on. But the ratio would apply because while delivering the judgment, while the trial court, the judgment of Selvi was there. So in whatever fashion it was taken, but the ultimate ratio that's been laid down, that needs to be followed. Only thing, even if it was, let us assume for a moment, okay, the consent was taken in the correct, proper manner, because I will not argue on those lines, because those guidelines came subsequently, which was there, which had indicated by then that the test was already done. But we'll have to see the parameters laid down by the Honorable Supreme Court in the judgment. No recovery was done in Section 27. So the reliance on this report is absolutely of no consequence. It's neither here nor there. Only if there had been any recovery under Section 27 pursuant to these tests, then for the purpose of corroboration, when these tests would.
If the charge or if the allegation is that you beat somebody to death, all right, what recovery can be made from you? The only whatever weapon or whatever.
Yes,
Otherwise, what else?
Nothing. It doesn't. If the test or the report of the test cannot be applied within the parameters as laid down, then it needs to fall flat.
May I show your lordship the reports? They will make things clear.
No,
Page 128.
Only 2 minutes to you.
No, page 128.
Yes.
128 is the expert's opinion. At page 129, the second last paragraph. The content your lordship will not look at. The second last paragraph. At 129, Mr. N. Jose, when subjected to polygraph testing, polygraph test showed changes which were indicative of his deception to the following questions. And those questions were related to the incident and the death. At page 130, second paragraph is the conclusion of the expert. Responses were known to the above questions. Polygraph tests show that the accused was not telling the truth about the above incident as observed from his responses and physiological changes which were indicative of his deception to the above set of questions. This was confirmed during repeat test. Thereafter, however, the same thing. This is polygraph.
Yes, but Mr. I mean, our question to you would be obvious.
Madam.
But if you ask somebody, is it true that you have thrown the stick at Anil to stop him from running?
Madam.
Or whichever question is, or the question number 21. Is it true that you have beaten Anil with the stick?
Madam.
Right? And if the report says that he was not telling the truth,
My lord.
one doesn't follow the other. Doesn't mean that yes, I have killed Anil with a stick.
No, it means that what are these tests called? These tests are not truth tests. All these tests are called DOD, detection of deception. The idea is to indicate from the accused person's physiological responses, brain mapping, whether he is telling the truth or not. That is trying to deceive or not. That's all. It is not a conclusive thing. That I agree with Mr. Talis. We will not open that door because then there will be a big problem. Any person may give any response. The response is not what is a desirable response. It's not what we hear yes or no. It is whether the response is showing his conduct, which is admissible under Section 8 of the Evidence Act, as a conduct intending to deceive. That's about it. So this comes as a circumstance under Section 45, the opinion of the expert, and under Section 8, it throws light on the conduct of the accused. This fits in with my entire argument that they were misdirecting the prosecution. Now I'll show you also how it works in reverse, page 140. Kindly recall, two of the witnesses, Rajesh and Satyendra, were also suspects. They were also sent for brain mapping. Now, this brain mapping is done at page 140.
Rajesh is the one who died.
Satyendra is examined as PW3. So, that test is done at page 140. The finding at page 143. Sorry, is the analysis. The last line, if your lordship sees. Yes, the responses showed normal activation to relevant words and to neutral words, primarily including high level of activation, high auditory semantic processing are not seen. So these two people did not have a violent mental response to the trigger words. On the other hand, if your lordship sees page 144, this is of the two accused.
And 133 just says that possession of knowledge about the activities.
Yes, that they have knowledge about it, but the distinguishing line is 142. But the high level of activation, high auditory semantic processing were not seen in the witnesses.
Yes.
So far as Jones and Hon'ble are concerned, their test is at page 134.
Yes.
The relevant portion, the same portion findings is at page 137. Here your lordship will see the really high levels of activation. The activation is described in the earlier paragraph. The changes in the activation pattern produced by the list of target mentioned for Jones and Hon'ble have elicited greater positive activation pattern consistent with experiential knowledge of the same. High auditory semantic processing are indicative of the active involvement of the activities listed above. Greater activation seen. The major findings at the bottom is that they were directly involved in the case. There is active participation as opposed to active knowledge in the other situation. So this report will not go. But the finding that these people had active participation in the incident involving the death of the deceased, Anil, cannot be ruled out. And thereafter, page 150 is a marker, which your lordships I was describing. Page 150, your lordship will see page 151.
Yes.
So he is slowly taken under with sodium pentothal. The description of the procedure is there. Revelations in the trance. Now at this stage, I am supposed to prejudice this court by showing the court the revelations. But as Mr. Tabas would say, these are not really admissible. But this is what the man's subconscious has said when he was under the trance. Thereafter, revelations of Hon'ble are at page 153. And finally, at page 155, the expert certifies her conclusion that these revelations have been made when the person was in a state of trance. So reading these three together, I'm not saying that the amount of confession, that the amount of circumstance your lordship can convict them on. Yes, I am saying that they read through the expert opinion are indicating that these people had direct participation and knowledge of this. It is because of this report that the whole direction of the investigation changed.
Yes, so even if suppose we were to, even if we were to accept what you're saying, Mr. Kabir, then what do you say our conclusion should be? That the judgment should be treated as as being perverse?
My lord, because the circumstances were never discussed. Had the learned court below done what is usual, take each of the circumstances and say either why the circumstance is not true, or why the witness is not reliable, or the chain of circumstances has been severed. There's no complete chain. Any one of these discussions would have served the purpose that the court applied its mind and came to a possible finding to this. Now, if there are two possible findings, and the court was justified by saying, yes, this is one possible finding, and the examination of evidence was there and it was not perverse. I would have nothing to say. Here, what has the court actually said? The court has said, I am ignoring all the forensics. Why?
And the court has treated these evidence in what manner? Just
The
for
court has not even relevant, not even mentioned it. The court has given a two paragraphs of discussion. At one paragraph, the court has merely said that these have not been the way in which it has been done. Paragraph 69 to 72 of the judgment, since the report didn't say how the signs of deception were measured, so the paragraph can't be accepted. But the report is a complete document. I don't know what the learned court was looking for. Was it looking for an EEG reader which showed the spikes and the dips? Because the court doesn't clarify it. Merely says that the signs of deception, how they were measured, is not shown, so paragraph are not accepted. This is not the law. Thereafter, paragraph 73, brain mapping is described, but without any finding, any conclusion, the narco analysis is not even looked at. So there is no finding to say this is admissible, this is inadmissible. If it's admissible, to what extent is it admissible? If it's admissible and so far admissible, should I rely on it? If I rely on it, what sort of a circumstance would be? Nothing is there. So this goes. Thereafter, the circumstances, nothing. Paragraph 75, the court simply says there were 5 witnesses who claimed to be eyewitnesses. The IO has not been examined. I'm discarding everyone, which is absolutely not the law. If he wanted to discard, the only person to be discarded was PW9, who was the supposed eyewitness. But the rest of the witnesses never claimed to be eyewitnesses at all. There were pre-occurrence witnesses, post-occurrence witnesses, but no eyewitnesses.
Very well. Thank you, Mr. Kabir. Yes, Mr. Kabir, it's 2 minutes. 2 minutes to you.
The learned trial judge, I'm sorry, my lord. The learned trial judge, my lord, from paragraph 52 onwards, I'll not read it, my lords may just take a note of it, has dealt elaborately as to why the reports of these states cannot be taken into consideration.
Mr. Kabir से note करना. Yes.
Yes. Paragraph?
Paragraph 52 onwards, my lord, 52, 53, 54, 55, 56. Up till, rather, in fact, up till 60, from paragraph 52 to paragraph 61. The judgments have been taken into consideration, not only the judgment of Selvi, but the other judgments that have followed Selvi thereafter also.
Yes.
It is not the case of the prosecution or the de facto complainant that something was argued or something was placed before the court and it was not considered. But they cannot be permitted to make out a new case over here. They'll have to make out a case from the evidences which is available. And in the infirmity in the judgment needs to be pointed out.
Yes. And what do you have to say about the report?
Report, my lord, as I have already submitted, my lord, the report has no evidentiary value because firstly, it offends Article 20 sub Article 3 of the Constitution of India, and it's not an absolute test where that the court can rely upon. The authenticity or the perfectness in the test has been dealt in the case of Selvi versus State of Karnataka, my lord. It is only for the purpose of corroboration, and corroboration particularly we cannot say anything, because now if the judgment says that only if the recovery is there, and then you can use it for the purpose of corroboration that this test was done, and as a result thereof this recovery has been done, and therefore for the corroboration for the purpose of investigation, trial, or the judgment's conviction, or whatever it may be.
Very well. Judgment is from 168.
My lord,
The problem starts at 162.
yes. (162 to 197).
Learned counsel appearing for the appellant. And the private respondents have clarified certain queries of the court. Stop. Next, reserve for judgment.
Obliged, my lords. If
I didn't have enough.
Just 1 second. One more thing I want to. But may I just add one final line?
Yes, yes.
In the assumption that your lordships are with me, and the conviction is forthcoming, your lordships have not heard Mr. Binnu and Mr. Tabez on the point of sentence.
Yes.
In the event that such situation arises.
Correct. So what do you propose to do, Mr. Tabriz,
my lord,
on the point of sentence?
if my lords ultimately holds the other way, then it will be listed once again for the purpose of quantum for hearing on the quantum of sentence.
We make it clear. It should be recorded that we have not heard the learned counsel appearing for the private respondents on the point of sentence. Just 1 second, please. Just delete that, please. Learned counsel appearing for the, yes, Mr. Tabriz?
Possibly, it's not necessary.
Yes,
for the
yes,
lord.
that's right.
My lord may just say that the appropriateness of
No,
the sentence
it is not
is
required.
This has not been.
My lord holds it other way. When the occasion would arise, then only my lord would list it.
That's something that has not been done.
Yes, we will consider
Appropriate.
listing the matter at an appropriate stage. For other submissions, for further submissions of the parties if required, if so required. Stop.
Deeply obligement.
People later will already know.
Item number 4,
Hmm.
CRA 12 of 2022.
Respondent was served with the notice. Despite his receiving notice, he has not proposed to appear into the court. And there was a specific order upon the registry to appoint a lawyer from Senate. That order was there on
So you're the appellant here.
16th of January. Yes, I have the appeal. You know whether the SLSA lawyer will be appointed for the respondent or not.
No, there's a registrar's a letter of 25th January. The communication, a communication of the learned registrar of the circuit bench dated 25th January 2024, pursuant to the direction of the last of the coordinate bench dated 16th January 2024 is placed before us. Stop. The registrar's letter, the registrar's letter is to the first line says communication of the registrar. What does it say? To the SLSA, Port Blair, then pursuant to the direction. Next, it is not clear whether the secretary, SLSA has taken any further steps pursuant to the registrar's communication. Pursuant to the communication made by the learned registrar. Stop. Next, list this matter before the next circuit bench. Stop. Learned counsel appearing for the appellant will be at will have the liberty of mentioning the matter for listing. Stop. The registrar, the learned registrar is requested to indicate to counsel on the steps taken by the SLSA pursuant to the letter dated 25th January 2024 in the meantime. Indicate to counsel in the meantime on the steps taken by SLSA. Any other appeals which you want to do? We don't see any point in taking our appeals today. Public interest.
My lord, item number 7 can be disposed of.
7. It's a public interest litigation.
Yes.
How can it be disposed of? Who is for the petitioner?
Mr. Venu Kumar. It is regarding increasing the circuit bench of CAT. Now the CAT has,
So how do we dispose it of in his absence? Tell us. You're saying it can be disposed of.
my lord, now the circuit bench has increased to 5 benches and every Thursday football matter is taken up. So
Every Thursday.
every Thursday, the grievance has been addressed.
You're there for the.
Vinu Kumar is there.
Yes, although 7 call 7, please.
Item number 7, WPAP on of 2023.
So you're saying that pursuant to Mr. Kumar's petition, it's been increased. What are you saying?
No, my lord, earlier there was
only three judges were there. Now the fourth judges has been, vacancy has been filled up. And earlier, four circuits was held. Now the circuit has been increased to 5 circuit bench yearly in India. And every Thursday Andaman matter is been taken through VC.
So that was all that Mr. Kumar had paid for?
Yes, ma'am.
That was all?
Yes, ma'am.
Look at the petition report. Every successive month?
Every month it cannot be possible, ma'am.
No, it says every successive month.
Yes.
And islanders to file service matters directly before the honorable court. You can't do that.
Can be.
Where I. To enable the islanders to file service matters directly before the honorable
Before
court.
the Honorable High Court, it cannot be. Service matter has to be scheduled, matter has to be, before the court.
This is,
There are other issues involved perhaps. It's not as.
No,
On Mr. Kumar's behalf, may I pray for him? That will be taken.
no,
yes, the responding numbers 1 and 4, where I is on the high court.
yes, my lord. High Court cannot,
Then
it is not maintainable, my lord, I. It is or, it is or. It is not and, it is or. II is not maintainable.
you are not happy with the cap, you want the high court to take up these matters.
No, my lord, Vinu Kumar has filed this case. I am for the cat.
Yes.
This
you-
is
For the next second, Mr. Kumar is in some difficulty. There are more issues here.
unnecessary. There is no issues.
There are two issues, Mr. Kabir. One is excessive amount of tax and the other is high court to directly file service matters.
It is, we who practice are aware that there are many difficulties with the cat's functioning, so Mr. Kumar would definitely have some grounds to it. Let it be disposed of in his presence.
Very good.
Coming of the judgment of L. Chandra Kumar, all the service matters were filed before the Honorable High Court. Now, after the judgment in L. Chandra Kumar, then the tribunal was called. Possibly, Mr. Kumar's submission is that if the central government is not in a position to provide so many numbers of circuits over here, because the matters, there are a lot of matters that's been filing up and we are not able to. Say for example,
Now it's what, five times a year?
this is also not sufficient.
It's not.
So the alternative prayer, what I could understand was that if the central government is not in a position to appoint the members in the tribunal and not provide number of circuits, then this notification may be withdrawn. So that the jurisdiction of the tribunal is outside and we may be permitted to file it directly before the Honorable High Court as it used to be before the judgment in L. Chandra
So
Kumar.
it's not as simple as what Mrs. Sivadam, 5 circuits instead of 4 and 4 judges instead of 3. It's not as simple.
No, my lord. That claim they cannot make.
Who cannot take the tax?
Petitioner cannot make.
Access is a fundamental right.
15, 16.
Okay.
Don't they being heard? So Zimbabwe is a-
If my lords would see, if my lord would remember the other day, the 2018 matter over the interim order continued and 2023, the summer. My lord, it continued. In spite of a repeated request, the matters are not being taken up.
Very well, yes. Adjournment is paid for on behalf of learned counsel appearing for the petitioners in the public interest litigation.
Not can record Mr. Tabriz's.
No.
Learned counsel appearing for the respondents submits that the PIL can be disposed of since there has recently been an increase of 1 member and an increase of 1 circuit in a year. 1 member in the bench of the tribunal and an increase of 1 circuit of the tribunal in a year. Stop. Next, Mr. We can record your names. Yes, Mr. Padwaz and Mr. Kabir, who are present in court, informs us but there are other pressing issues which need to be adjudicated. And mere increase and the increase of a member or of a circuit cannot resolve the concerns, what concerns raised in the PIL. Stop next. After hearing the council after hearing the council we have the view that the PIL should be disposed of either in the presence of Mr. Kumar, after taking note of all the issues which have been raised therein. Stop. Next, list this matter before the next circuit bench.
Obliged. Obliged.
We will sit in at 12 o'clock. Or maybe 12:10.
Item number on WPA 11 of 2024, item number 2, 3, 4, and 5.
The above discussion persuades this court to dispose of these writ petitions in terms of the answers given to the four issues and the directions as follows. I. The condition restraining transfer of permits or any other conditions to the same effect cannot be seen as being outside the statutory framework. There is no scope for interference with regard to notices issued with specific regard to the transfer of permits or against the person who is otherwise unauthorized to drive the auto rickshaw. II. There is no scope for interference with regard to conditions which form the part of the permits at the time of issue and are within the parameters of the MV Act, including sections 73, 74, 82, and 86 thereof. Next, the respondents shall not give effect to the condition/requirement for production of islander identity card, local certificate, since such condition is not within the statutory contemplation. The condition has also been brought into effect through meetings without following due procedure. The respondents shall not give effect to any conditions which were imposed subsequent to the date of the grant of permit. This would mean conditions which were not part of the permits granted by the respondents. The court finds substance in the petitioner's contention that the petitioners could not have been and indeed were not aware of the additional conditions imposed by the estate through its meetings after the initial grant of permits. Next, the respondents shall only impose conditions within the mandate of sections 73 and 74 of the MV Act for grant of new permits. For grant of new permits for auto rickshaws, the respondents shall comply with the statutory requirements, including under sections 84 and 85 of the MV Act 1988. Any additional conditions, including that for production of local certificates, islander identity cards, will have to be put through the procedure envisaged under the MV Act and the ANN Islands MV Rules 2006. Next, the respondents shall be restrained from giving effect to the impugned notices, including for suspension or cancellation of permits, only if the notices were issued within the statutory mandate of sections 82 and 86 of the MV Act. Last, any conditions which are subsequently imposed are to be applied on and from the date on which the conditions are communicated to the stakeholders. The interim order dated 10/1/2024 stands modified in terms of the above. The four writ petitions, along with numbers, along with connected applications, are accordingly disposed of by way of this judgment.
Item number 6. Here are 18 of 28.
Yes, are there any matters which you want to do? Both sides here? Yes,
Madam, this matter, okay, so for the new Kumar is appealing for the respondent.
respondent. Yes,
For recording of the order dated 17/1, part by the Hon'ble Court for keeping the matter taken by this matter before the principal. So I say that matter
which order?
17, the page number 42 can be seen.
So the review, the learned judge is available. How could the review be read? The learned judge has treated the matter as part heard. How do you want the recalling of that order?
It's not possible to argue in, virtual manner.
Very well, then the matter will be heard by the learned judge who passed the order. Yes, this is an application for recalling an order passed by a coordinate bench on 17th January 2024. Stop. By the said order, comma. Next, by the said order, comma. The revisional application was directed to be marked as part heard. And the records were to be placed before the principal bench. Stop. The matters were made, the revisional applications were made returnable for hearing on 17th February 2024. Stop. Next. There, prima facie, comma, there appears to be no case made out for recalling this order. Stop. In any event, comma, since the learned judge thought it fit to hear the matter and also to make it returnable on 17th February 2024, comma, this court is not inclined to entertain the present application. Stop. Next, the applicant will have liberty to approach the learned single judge who passed the order on 17th January 2024. Stop. Next, who passed the order on 17 January 2024 for appropriate orders. Stop. Next, I'm disposing of the CRAN. All right. CRAN 1 of 2024 is disposed of in terms of the above. Next.
Item 7, WPA 942 of 2023.
I appear for respondent, my lord.
Who is appearing for the petitioner, Mr. Sivabalan?
Mr. K. Sabir.
No one appears for the petitioner. List this matter before the next circuit bench.
Obliged, my lord.
This matter, my lords, the principal matter, my lords, has gone to the next circuit.
There is
my
no
lords.
principal.
next circuit.
Let me
This
place, my
matter-
lord.
Item is for final hearing, my lord.
Let the matter be called on.
Yes,
Item 8, WPA 236 of 2023.
the authorities are in a hurry. Some of the matters.
No.
Yes, what is it, Mr.
Well,
Kabir?
the issue is very simple, my lord.
No, what is it about the principal matter being?
No, there are two identical matters. One has been filed by Mr. Binu Kumar and one by me. So there is no principal matter. Either if any of the matter is decided, the other would
No, what is the issue in the matter?
issue, my lord. During the year 1962, my lord, there were a lot of settlements have taken place in these islands. And during that settlement, my lord, 2 hectares of lands were given to each of the islanders, which was 5 acres of hilly land and 5 acres of paddy lands, my lord. And subsequently, in the year 1966, this Andaman and Nicobar Islands Land Revenue Land Reforms Regulations was notified, my lord. Well, let's just see, there's just one simple interpretation.
What is your prayer?
Well, my lord, if my lords may just bear with me just for a moment. Regulation 159, my lord, it says, no occupancy tenant shall have the right to transfer his interest in any land if such transfer of the total extent of the land held by him will be reduced below 2 hectares. So it says that if it is reduced below 2 hectares, then you have to sell out the entire quantum of land. But the question would be, my lord, if I have acquired a land, not an allotment, and the land itself is less than 2 hectares, then whether these conditions would apply to me or not. My lord, the petitioner, my lord, she holds 2 plots of lands. If my lords would kindly come to page 30.
So your prayer is for directing the sub-registrar to do what? To register?
To register. To register.
No, that is a final hearing. What is your interim prayer?
There's coming up a final hearing, my lord.
Final hearing?
Final hearing, my lord.
So after affidavits?
Yeah, my lord. After affidavits, my lord.
Yes.
My lords would see.
So you want an order directing the sub-registrar to register the sale deed?
To register the sale deed. They are, my lords, interpreting the provisions of regulation 159 to
Regulations?
regulation, my lord.
159?
159 to then Roman 2 thereafter, my lord. One hectare would be 10,000 square meter. 2 hectares would be 20,000 square meters, my lord. Now, if my lords may kindly come
Mr.
up.
Tabriz, what order do you want now? I will have to hear Mr. Chakraborty also, and then you.
My lord, this matter, my lord, this little urgency, if my lords would remember, it was a serial number 82 I had mentioned for upgradation. For the past 2 circuits, I've been trying. This lady wants to sell this property for treatment of her son, my lord. He has to undergo a liver transplant, my lord.
Yes, so how are they interpreting this provision?
My lords may kindly come over to page 47, my lord.
No, 159 you were placing.
Yes, the interpretation of the authorities is appearing at page 47 of the.
No, it says fight to transfer. That's what the marginal note is.
No occupancy tenant shall.
No. What is this fight to transfer? FIGHT.
Right, it ought to be right to transfer.
Yes.
This is how. That's prophetic, the person who has framed the regulation. Well,
Yes.
it says, no occupancy tenant shall have the right to transfer his interest in any land if after such transfer, the total extent of the land held by him will be reduced below 2 hectares. Now here, my lord, the writ petitioner, my lord, she holds 2 plots of land. One is about 3,100 square meters and the other is about 1.55 hectares, my lord. Now, the only question would be if the land itself, though I have raised a lot of issues in the present writ application, I will not be pressing those, the constitution.
So the provision is that post transfer, it cannot be reduced to 2 hectares.
2 hectares. But if a land itself is less than 2 hectares, if I hold property which is less than 2 hectares, then whether these provisions would apply to me or not.
Yes. So what is their construction?
Their construction, it will apply to even lands which are less than 2 hectares.
Their construction of this particular regulation?
Yes, my lord.
Yes, show me that construction, please.
At page 47, my lords. The applicant has applied for obtaining OR report of land bearing survey number 8/5, area 3,100 square meters.
So this is what is impugned in the
This is
petition.
impugned, my lord. This is impugned.
What is this? What is the date of this? It's a part of the decision.
My lord,
1st January 1974 is what the date of birth.
date of birth of the applicant, my lord.
Yes, and what is the date? What is this part of?
This is, my lord, we have to.
17 December
17 December 2020. These applications, we make it online.
OR report is what? Issue of OR report.
It's a self-generated mechanism which is unknown under the regulation. my
And
lord.
this application was rejected by the Tehsildar.
I had applied, my lord, for registration of the sale deeds, my lord. It was
Yes.
submitted before the sub-registrar.
Yes.
Sub-registrar called for a report under section regulation 159 from the Tehsildar. Tehsildar has submitted this report saying that if this transfer is allowed, then it would contravene regulation 159, my lord. My submissions would be, my lord, this will not contravene 159 because the land itself is less than 2 hectares. This would apply in cases only where the quantum of land is more than 2 hectares.
And you are an occupied tenant.
And this land I had purchased, it's not an allotment also. Those arguments of I'm not making constitutional validity, right to hold the property, dispose, all those things, I'm limiting it for the present only to the interpretation so that at least this matter can be decided, my lord.
No, so just says that violates section 159 to I.
Yes, my lord. It says the applicant has applied for obtaining OR report of land bearing survey number so and so.
What is OR report?
Occupancy right report.
Occupancy rent.
Right.
Right.
Occupancy right report.
Yes.
Of land bearing survey number 8/5, area 3,100 square meters, classified as hilly, situated at Supighat, jointly recorded in favor of Srimati Sabita Mandal, wife of Shambhu Mandal and others. There are 10 people holding it. My share is only 200 square meters in this manner.
Yes.
However, another land bearing survey number 194, measuring an area of 1.55 hectare, classified as hilly, situated at Supighat, village, jointly recorded in favor of Sabita Mandal, wife of Shambhu Mandal and others fall in the same village. Therefore, thereby violate section 159(2) of LR and LRR. They just say how it violates. There doesn't say the interpretation. Basically, they mean to say is the quantum would come down to less than 2 hectares, but the land itself is less than 2 hectares, my lord.
No, where do I get that from? That is less than 2 hectares.
The calculation, my lord, if we read, the first survey number is 3,100. Hectares, 0.3100 hectares. So
Yes.
this would be 3,100 square meters. Out of which I hold, my lord, if my lords may kindly come to page 32.
Yes.
32.
Yes.
Not 32.
Yes.
The schedule of property, my lord, not 32. It should be page 43. I hold a share of only 400 square meters out of the opposite plot of land. The schedule of property is given there, my lord. And
No, schedule of property, this is only in the name of the petitioner.
petitioner, my lord, she holds 400 square meters in the total area of 3,100.
100 hectares is 400 square meters.
No, my lord, it is not 400 hectares. It is point.
No, 0.0400.
This would be calculated as 400 square meters, my lord.
Yes.
1 hectare, my lord, is 10,000 square meter.
Yes.
Even if, my lord, even assuming for a moment, if the total area is 3,100 is also taken, then the calculation also doesn't cross over to 2 hectares. That is 20,000 square meters.
What is the total area?
Under the regulation, it should.
No. What is the total area which you and the others are holding?
In the first survey number, out of 3,100 square meters, my lord, I am
Yes.
holding only 400 square meters, my lord, which I intend to dispose.
Yes. And what is the first page of this? How do I know that this is the petitioner?
Where, my
That this pertains to the petitioner?
lord? Page 37, my lord.
Yes.
The survey number is given, my lord. The petitioner's name,
Sabita Mandal.
Sabita Mandal, my lord.
Yes, so the subject matter of challenge is page 47.
47, my lord.
Which prayer is that? Not mentioned, just direction.
Yes, my lord. Without insisting for production of that report, and my prayers are the report appearing at page 47. Firstly, the sub-registrar, my lord, he has to act within the
No,
parameters
what report have you been asked to produce?
at page 47, my lord, the occupancy right report, my lord, OR report.
Does it say that the applicant has applied for obtaining OR report?
My lord,
So does it say that you have to produce it?
my
What is
lord,
it?
that's the mechanism. I have said so, my lord, in my writ application.
Yes,
If my lords would kindly see at page 4, paragraph 5, the mechanism established by the sub-registrar is that once we submit the deeds for registration, the following documents are being insisted on. That's number one is valuation certificate, which again I am not pressing for because there is no provision under the regulation where the tehsildar can give a valuation report, particularly when the circle rate is there.
yes.
Then second is no deed non-encumbrance certificate. Even that is unknown under the regulation. Third is the occupancy right, which I say. And fourth is record of right and sketch map. That's definitely to establish my title, my lord. Sub-registrar basically at best can ask for the records pertaining to the property. He cannot ask for things which are not within his scope under the Registration Act, my lord.
And Tehsildar has dismissed your application.
My lord,
And your application was for occupancy right,
occupancy report,
occupancy right report.
my lord.
Yes, Mr. Chakraborty?
My lord's first submission is my lord's writ petition. I have said so in my affidavit in opposition at para 6. My lord, the writ petitioner has herself applied for valuation report for no due certificate, non-encumbrance certificate, and also occupancy right.
Yes.
Petitioner has herself applied for these things, and now my lord, the petitioner is challenging the fact that these are requirements so as to eventually get the permission for transfer. My lord, that is the first point. My lord, the second point is, my lords, in the other matter, that is case of K. Sudha, where Mr. Kumar was appearing, there was a direction of the Honorable Court, my lords, to file a report to explain on the applicability of Regulation 159 to holdings which are less than 2 hectares. And pursuant to that, my lords, on a report was filed, my lords, on 13 December 2022. That report, which was filed in the other matter, has also been annexed, my lords, with our affidavit in opposition as annexure R1. If my lords has our affidavit in opposition, annexure R1 at page 6.
Affidavit in opposition, that's it. Yes, at page 6.
Yes, my lord, it says 13 December in the matter of K. Sudha, which is the matter which has gone to the next circuit. The writ petitioner, Srimati K. Sudha, wife of such and such, through power of attorney, filed writ petition with direction upon respondent among sub-registrar to accept and register sale deed executed between her and Kamli Singh. As per the report received from the sub-registrar, the writ petitioner, through a power of attorney, had submitted sale deed dated 13 May 2022 along with supporting documents in respect of land bearing survey number such and such, ad measuring 0.02 hectares situated at Calcutta village. The petitioner got appointment token such and such, as the entire process of registration has been digitized. Same is done through National Generic Document Registration System. Petitioner was issued no dues, valuation, and OR report such and such by Tehsildar. During scrutiny of the sale deed and supporting documents, which is prerequisite procedure before registration, it was observed that by the sub-registrar, the Tehsildar Port Blair in his occupancy right report has mentioned that the subject transaction would contravene section, my lord, they call it section here, my lord, section 159 of the 159 subsection 2 subclause Roman 2 of the ANN Islands Land Revenue and Land Reform Regulation. As per section 159 2.2 of the ANN Island Land Revenue and Land Reform Regulation, no occupancy tenant shall have the right to transfer his interest in any land if after such transfer, the total extent of the land held by him will be reduced below 2 hectares. As per section 159(6), notwithstanding anything contained in Indian Registration Act, no officer empowered to register document which purports to contravene the provisions of this section. As per record of right annexed as such and such, the writ petitioner, land bearing such and such, area 0.02 hectares, survey number such and such, again 0.02 hectares, all classified as hilly,
held under occupancy right comprised in holding number such and such at Calicut village under Port Blair Tehsil stands recorded in favor of Srimati K. Sudha. As such, petitioner holds total 0.23.
No, please, Mr. Chakravarti, don't mention, what does it say? Just tell me.
So, my lords, the submission
This is some other petition anyway.
yes, my lords, because both matters were being heard together. So, my lords, the submission is, my lords, that under 159(2)(2), my lords, there is a specific regulation, my lords, which requires that it has to, that after transfer, that it has to be minimum 2 hectares have to be maintained. So, my lords, today, my lords, that a plain reading of the provision will show, my lords, that they essentially want striking down of that provision, my lord. So, my lords, here, my lords, are what we have in our affidavit in opposition explained, my lords, that the reasoning there, if my lord sees the entire regulation, my lords, there is a restriction on, firstly, all the land is owned by the administration, my lords, here. And right to property, my lords, is not a fundamental right. And my lords, there are geopolitical reasons why this has been done, my lords, because only 95% of the land is under forest, 3% of the land is agriculture, that leaves only 2% of the land, which is revenue land. My lords, if the reason why this
Revenue land, does it?
revenue land meaning land which is either municipal or which is not agricultural or forest.
Yes.
So, my lords, this is only around 2% land is available, my lords. Now, my lords, if my lords, let us assume what the petitioner understand what the petitioner is submitting. The petitioner's contention is that if there is a larger tract of land, then this provision is fine. That after the transfer, it should be minimum 2 hectares. But what is the reasoning? The reasoning is the same, my lord, because the reason to restrict this is that the regulation the mischief of the regulation is that small tracts of land should not be transferred. So, my lords, if somebody has 4 hectares and this regulation comes in and prevents him from selling off 2 hectares of land or less than 2 hectares of land, which is residue after he is able to sell those 2 hectares out of the 4, the same reasoning will apply even to somebody who has 2 hectares or less than 2 hectares. Because the intention is, my lords, that
is to maintain 2 hectares, is to maintain 2
is to
hectares.
maintain a minimum amount of land, because, my lords, the fear is, my lords, that tomorrow there could be, if, for example, if it is agricultural land, my lords, if there is out of 3% agricultural land, if somebody has 2 hectares of agricultural land and they are able to sell small parts of it, my lords, then eventually, my lords, the concern that if 2 hectares is further subdivided into several smaller pieces of land, my lords, the ultimate objective of preserving the agricultural character would be defeated, my lords, because smaller tracts of land would then be converted, my lords, for commercial purpose, for some other purpose which is not permissible. So, my lords, if this regulation is to be struck down altogether, my lords, then because if this regulation is found to be dehored some fundamental or constitutional right, my lords, then that, my lords, is a separate issue, my lords. For that, they'll have to justify that why the regulation as a whole should be struck down. Otherwise, there is no discrimination between somebody who has more than 2 hectares and somebody who has less than 2 hectares, because the purpose is the same. The purpose is that smaller tracts of land should be held and they should not be transferred, so as to prevent some kind of rampant commercialization or activities which would eventually create further strain on the resources. There is no difference in the treatment of somebody who has 4 hectares and is required to maintain 2 hectares with somebody who has 2 hectares and is required to maintain 2 hectares. Because the purpose is...
No, the petitioner's case, according to Mr. Tabrez, is that the petitioner holds just whatever that 400 square meters.
Yes. So, my lords, the purpose is to ensure that smaller tracts of land are not transferred. My lord, therefore, that principle will apply to a person who has 4 hectares and is required to maintain 2 hectares and therefore cannot sell 400. Sorry, I'm not very good with the metrics. That system, what is it? 400, whatever, the 400 subpart of 2 hectares. That the intention is to prevent that from being sold. Now, that same principle will apply even to a person who has 400. Because the idea is that those smaller tracts of land which are given to settlers on this island for the purpose of their living, for the purpose of them to build their house or for agricultural purpose, that should not be sold off to, my lords, for commercial purpose or some kind, which will eventually put a huge strain on the resource. And if my lord sees these regulations, my lords, the regulations, every provision in the regulation has a restrict. Then this 1966 regulation, if my lord considers the various provisions contained in this regulation, my lords will find that throughout the regulations there is a restriction, my lords, because of the peculiar nature of the geography and the situation that prevails in the islands. So, my lord, this regulation 159 is in adherence to that. If
the object and purpose of this 1966 regulations, one of the object and purpose is to prevent, my lords, transfer of land for commercial purposes, to restrict it, my lords, for various reasons. Now, this 159 is to be read in that light. So, my lords, it will further the object and purpose of the regulation to say that less than 2 hectares also cannot be transferred.
Yes, I've understood. Yes, Mr. Tabris.
My lord, I'm not seeking for a prayer to striking down the provisions of 159 to my lord. I'm only saying that the interpretation adopted by the authorities is incorrect, my lord. Definitely, right to hold a property is not a fundamental right, but it is a constitutional right, it's a human right, and that's been well established, my lord. My lord, the only
No, whether regulation 159 is ultra virus.
that's not the issue.
No, part 3, part 4, any other right, that will be a separate discussion.
That's a separate discussion. The only thing is whether the interpretation adopted by the authorities is right and justified. Whether this would apply in relation to lands which are itself less than 2 hectares in its measurement, my lord. Because the intention, my lord, the intention is that the larger chunks of land should not be reduced, but this will not apply to lands which itself is less than 2 hectares. 2 hectares means 20,000 square meters, my lord. The land which is sought to be sold is 400.
No, Mr. Chakraborty, I will do this.
My lord.
I will set aside this order and I will say that the order is unclear as to the extent of the ground given that it violates regulation 159.
My lord.
And I will direct the which is this Tehsildar to consider it with particular regard to the fact that you only hold 400 square meters of land.
400 square meters in one survey.
Because what you are saying, Mr. Chakraborty, that is, I can understand the argument of the mischief and all that, but certainly not spelled out in the order. Just says violates regulation 159.
My lord.
But the question is, Mr. Tabris, whether that will give you any relief.
I'll have to come back again.
Orders must be passed to GIS in that context.
If it is demanded, my lord, definitely I'll have to come back because in the other matter.
Because Mr. Tabris, honestly speaking, I am not convinced that you have a clear-cut case on your interpretation of regulation 159.
Then I'll have to address on
The mischief angle is there. Because otherwise it will, any person, even if I discount what Mr. Chakraborty is saying, any person who holds land which is less than 2 hectares can just go on alienating nearby.
There can't be any bar, my lord. This is an absolute violation of the constitutional right.
Yes, but no, second part, you have a weak link. Constitutional right, I'm telling you. So I don't want to make any observations or comments on that. But right to alienate transfer, that you can do, but your interpretation of 159, that is not, I don't use the word foolproof, but.
Lord, what had happened, as I had said earlier, in this 1962, my lord, when settlements were made, 4 hectares of land were given to the.
What do you think I should do? But I will set aside the order anyway.
The point of sending it back, my lord.
I will put it in the next circuit also.
Let it be in the next circuit. Because sending it back would only prolong the matter.
Because it's not such a clear-cut case that 159 you will not apply to you at all because you hold less than 2 hectares.
Says will be reduced below 2 hectares. So the reduction has to be, there has to be reduction in the quantum and the reduction should be less than 2 hectares. But what if the land itself is less than 2 hectares? That's the only issue which I am saying, my lord.
My contention is, my lords, if an interpretation has to be made of the object and purpose of the statute. So if the object and purpose of the statute is to restrict transfer, then my lord, the interpretation is correct.
The object cannot be derived.
1 minute, Mr. Tabris, I will come to you. Yes,
So my submission is, my lord, if the entirety of the regulation is seen, and my lord, if the object and purpose and the correct understanding of the whole regulation is taken into account, my lords, then, my lords, the interpretation of 159 has to be in accordance with that. So it cannot be contrary to the object of the rest of the regulation or of 159 itself. if the object of regulation 159 is to restrict transfer for less than 2 hectares, then naturally, my lords, in my humble submission, it would also amount to restricting transfer for persons who are holding less than 2 hectares. What my learned senior is submitting is that if somebody holds 2 hectares, he is required, if somebody holds 4 hectares, he must keep 2 hectares. But if somebody has 1.99 hectares, he can be allowed to transfer. Well, that is not in furtherance of the object of the statute, my lords. It is not an interpretation which flows either from literal reading of the regulation. The regulation itself may be challenged, that's a separate issue. But my lords, a reading of whether statute, literal interpretation or purposive interpretation or mischief rule, whatever principle is applied, my lords, in my humble submission, this 159 can only mean that even it will apply even to people who have less than 2 hectares, because the idea is to restrict 2 hectares. So if 2 hectares is the peg, can it be said that somebody who's 1.99 can transfer, but just because he has 1.1 hectare more, he'll be prevented from doing so? That cannot be a logical interpretation of the provision. If the provision as a whole is struck down, that's a separate issue. That has to be addressed differently.
If somebody acquires 2 plots of land, he is compelled to sell both of it. He can't sell one and can't retain one. That's the interpretation what the authorities say.
Yes, the crux of the dispute centers on is on the interpretation of regulation 159 within brackets 2 within brackets II of the A and N regulations, 1966, which prohibits an occupancy tenant from transferring his interest in any land without keeping a minimum balance of 2 hectares of land. Stop. Next. The petitioner admittedly owns about 400 square meters SQM of land, and when counsel appearing for the petitioner submits that the bar contained in regulation 159 II will hence not apply to the petitioner. Stop. Next, when counsel appearing for the respondents, on the other hand, argues that the provision must be construed in consonance with the object of the regulations, capital R, which was to restrict transfers of land without keeping the balance of, without keeping the minimum balance of 2 hectares of land. Stop. Council submits that the full stop. Delete. Next. The imperial order
Forty 47 minutes.
yes. Dated 17 December 2022 of the impugned order passed by the Tehsildar, dated 17 December 2022, prima facie, fails to address either of these points and contains Bare, B-O-R-E, bare dismissal of the applicants, of the petitioner's application for occupancy right report, capitals, on the ground that the sale would be on the ground that grant of such report, capital R, but grant of such OR report would be in violation of Regulation 159. Two, says one here.
By the typing mistake, my lord. One is mortgage.
Two, small I of the regulations, stop, presumably, comma,
No, in the original it is correct, it is two.
Yeah.
I've got one.
I of the regulations, stop. There is no the view that is not supported by any interpretation of the said regulation with particular application to the facts, to the fact of the petitioner owning less than 2 hectares of land. Stop. Next, wait, Mr. Kabir, I will not set it aside, I'll just keep it. Yes, next, however, comma, the court is unable to, the court is not in a position to entertain the matter to its logical conclusion being the last day of the circuit. Now, however, comma, during the last day of the circuit, comma, the court is not in a position to entertain the matter, to hear the matter to its logical conclusion. Stop. What, fireworks? What is happening? It's not fireworks.
Somebody on the sheet, I think, on the rooftop.
Yes, I thought it's celebration, that's it. And particularly when I said last day of the circuit, that's
That's at 4 o'clock.
Yes, what did I say last? Entertain the matter, hear the matter to its logical conclusion. Stop. Next, list this matter before the next circuit bench as prayed for.
Well, can the authorities be directed to file a supplementary explaining the,
Yes, considering the court's view on the opacity, O-P-A-C-I-T-Y, opacity of the impugned order, comma, the respondents shall file a supplementary affidavit. Shall file a report in the form of an affidavit explaining the view of the Tahsildar on regulation 159, 1 II.
2 II?
Regulation 2 II within 1 week from today. Stop. Within a week from today. Stop.
Obliged.
Any other matter which needs to be done? Which one, Mr. Kabir? That's CRR. So what do you want me to do?
my wife. My wife has been receiving maintenance over the last few months. She told the court she's not received anything. Thereafter, I was asked to file an affidavit bringing it on record. In the process of filing the affidavit, we realized that though transfers are going to her,
61 is Sri Alokram.
hello,
Yes.
she has blocked my access to her account. Can't transfer to her account. So we have made demand drafts and placed it before the learned court below. She's refused to accept. I was basically looking for a direction that she shares some form of a bank account or something by which I can comply with.
So Kabir, I can't pass such an interim order in her absence simply because it's not in the course of taking up the list, calling the list. So what I can do at best is I can say that this has been called out of turn. Very well. Yes, item 61. This matter has been called out of turn on the request made by learned counsel appearing for the petitioner. Stop. Counsel submits that the petitioner needs urgent directions in terms of access to the respondent, the private respondent's bank account, bank details in order to transfer money, in order to transfer the maintenance amount to the private respondent. Stop. Counsel submits that the private respondent has blocked access to her account. Stop. Next, since the private respondent is not represented, comma, this court is not inclined to pass any directions ex parte. Stop. Next, the petitioner, counsel is however given liberty to mention the matter on an urgent basis, mention the matter for listing on an urgent basis before the next circuit bench. Stop. Maintenance amount towards accommodation.